Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. So today we're going to talk about how a case gets from state court all the way up to the United States Supreme Court. And while it is simple in some ways, it's also quite complex in other ways. And I don't think most people appreciate some of the things that lawyers have to do in order to make sure that all their bases are covered. So let's take a hypothetical situation. John is a NFL place kicker, and he develops a wart on his kicking foot. And he goes to the doctor and says, "Hey, I need for you to treat this wart on my kicking foot." And the doctor says, "Okay, we can take it off." So the doctor uses nitrogen and liquid nitrogen and takes the wart off, and everything's good for a couple of weeks. And then he notices that the spot is back, so he goes to the same doctor who took it off, and he says, "Oh, yeah, that happens. It's a little discoloration. You'll be okay. Just, if it starts doing anything funny, call back, let me know." So 8 months down the road, he's kicking and his foot is really bothering him, and he shows his foot to the team doctor, and his team doctor says, "Holy cow, man, you've got melanoma." Well, now it's past the point where, he can do very much about it, and becomes pretty obvious that he's going to die. So he files a lawsuit. In his state, there is a limit on the amount of money that can be recovered for non-economic damages. Now, non-economic damages are things like pain, suffering, disability, loss of enjoyment of life, those sorts of things. And as a result, the courts there, no matter what the jury awards, so if the jury awards $10 million for pain and suffering, he can only be awarded $250,000. And he doesn't think that's right. So when his lawyer tells him that, the first thing he does is he says, "Hey, that's not right. You need to challenge that. They shouldn't be able to get away with that. I'm supposed to have equal protection of the law." And the lawyer says, "Well, our courts have looked at that and they've decided that that's constitutional." And his response to that is, "Well, I don't care what they say. I want to know what the Supreme Court of the United States says about that." He says, "I think this violates equal protection because I'm being treated the same as somebody who gets a minor burn and sues over a minor burn. Yeah, I definitely think their, pain and suffering should be capped because it's a small injury. But here you're talking about ending my life. I'm going to have to go through chemo. I'm probably going to pass away from this. This is not a small injury. This is a big injury, and my pain and suffering should be valued appropriately." Well, if the lawyer does not, in his initial pleading, where he files the lawsuit, add in there that they challenge the application of this damages cap, then when they take this issue up at trial and they challenge the damages cap, it's too late. By not putting it in there at the earliest possible time, which is when he files the lawsuit, well, it is considered waived. The defendant can also waive a constitutional issue by not raising it in his answer. Now, initially, most defendants file a motion to dismiss, and if that's not granted, then the next thing that they file is an answer. And in the answer, they have to raise any defense that they possibly have, including a constitutional defense. And they lay that out in their answer, and then the issue is preserved as it goes up through the state courts. But if they don't preserve it, then not only can the appellate court in that state not address the issue because you've waived it, but when you try to take it up to the Supreme Court, they will determine that you have waived it as well. If it wasn't passed on at the state level, they are not going to pass on it at the Supreme Court level. And courts routinely assume that, a trial court made the correct decision. Courts like the Supreme Court would routinely defer to the state Supreme Court in making that determination. So in this case, John's lawyer challenges the cap in his initial pleading and says, the law of the state, which says that I can only get $250,000, is a violation of my right to due process, substantive due process, and it is also a denial of equal protection under the 14th Amendment. With that in there, he'll take that up to the trial court, and the trial court will go, we've already been through that. It is absolutely constitutional. Bring your case. So let's suppose that he brings the case, and at the end of the day, at the end of the trial, the jury awards $10 million in pain and suffering and $5 million for the injury that he received. And as a result of that, the court cuts back the $10 million award to $250,000 because that award is capped. The plaintiff objects. The court overrules the objection and enters the judgment on the verdict by cutting back the award from the jury to $250,000. So the first thing that the plaintiff will do is they will file an appeal to the Intermediate Court of Appeals. In Missouri, that would be the Court of Appeals. There are 3 different divisions of that. There's the Western Division in Kansas City, the Eastern Division in St. Louis, and the Southern Division in Springfield. So other states have similar arrangements where they have an intermediate appellate court. It doesn't go directly to the state Supreme Court. Although there is a valid constitutional objection here, or at least what I would call a colorable claim here that there is a violation of equal protection, that doesn't mean that the Supreme Court, which usually handles all constitutional issues, will take this case. What normally will happen is it will go to the Court of Appeals, and the Court of Appeals will decide this issue as a matter of first impression. When the Court of Appeals affirms the trial court, saying, no, this has been decided and it's constitutional, then the plaintiff would have another opportunity to go to the state Supreme Court and say, please look at this. And if the state Supreme Court did and affirmed, then it could go to the Supreme Court. At the end of the day, there is a judgment that remains for the plaintiff that has been reduced to $250,000, and the person wants to take that to the Supreme Court. They draft a writ of certiorari, or a petition for a writ of certiorari. And basically what they ask the Supreme Court to do is to come and get a full copy of the record from the state courts, examine that record, and make a determination as to whether this is a violation of due process and equal protection. Now, assuming that happened, then that issue would get to the Supreme Court. The Supreme Court would have to decide whether to take that case. Here is the key thing, however, and this is an issue of federalism that, again, I'm not really sure most people understand. If the issue is one of state law, for example, the state constitution should rule this unconstitutional. It should be unconstitutional under the state constitution. Well, if that's the issue that's raised, that has to be decided by the state Supreme Court. And the reason that's the case is because state law is a matter of state concern, not a matter of federal concern, unless it transgresses constitutional guarantees like equal protection and due process, in which case then it can become a federal concern. But if it is a matter of state law, even if someone disagrees with it, the state Supreme Court's ruling is final on that issue. And that is something that's very important to realize. Now, the real question is whether the Supreme Court of the United States would take a question like this and make a determination based on the Due Process Clause and equal protection. They might or they might not. And it would depend a great deal on how frequently they see this issue, how, if it has been raised in the district courts and in the courts of appeal for that circuit, how those branches of government dealt with it. So if a Missouri plaintiff went over to Kansas to get medical care and was malpracticed upon and was subject to a $250,000 cap. They would have the right under federal law to sue in Kansas federal court, to sue the Kansas doctor in Kansas federal court. And even if they sued in Missouri, because it's a suit between the citizens of two different states, the Kansas defendant would be able to remove it to Missouri federal court. And then a Missouri federal judge would decide it. It would go to the Eighth Circuit, and the Eighth Circuit would make a determination about the constitutionality of that particular statute. Now, the problem is that in making that determination, the federal courts are making a guess about what the state courts would do in that situation, and they are guided by state precedent in that regard. So if this issue's already been raised and it's already been decided, then they are going to go with that determination. So there will be appeals to the circuit court on that issue, and that's going to be in the case law. So again, if it has been routinely decided that way, and that issue is prevalent throughout other circuits, and different circuits have determined it in different ways, well, then your chance of getting a review by the Supreme Court goes up. But if it is not something that they see a great deal, or if they determine that it's not a matter of general interest and importance, something that really has a significant impact on justice, that sort of thing, the Supreme Court is probably not going to take it, again, because they are not an error-correcting court. They are simply a policy-making court. And in that policy-making role, they have to look at federalism from the view of all of the states. And in a situation where each state has a different cap, in some respects, Missouri's cap now is up around $750,000 for certain kinds of injuries. Other states like Kansas are locked in at $250,000, and that has been that way since 1960. So that cap doesn't even increase with inflation, which is really sad and really strange, but that's the way Kansas law is, and that's the way Kansas law works. So given the wide variety of different states that would have different statutes in that regard, the idea that the Supreme Court could make one rule for all those states might be very hard to craft. You know, it is a cap of today's dollars at $750,000 that goes up with the rate of inflation. Is that constitutional? What about the Kansas statute that doesn't change at all? Is that constitutional? Can you make a rule at the Supreme Court that would address both issues? And if you can't, again, then it's fairly unlikely that the Supreme Court is going to get involved. Although the Supreme Court is not intimidated by state law questions, and they certainly have the ability to answer those questions as they believe the answer should be, most of the time they will restrain themselves from getting involved at that level just because they are not an error-correcting court. So that's what I have for you today. I have another video in this series that essentially deals with how a case gets to the Supreme Court through federal courts. Hopefully you'll have an opportunity to watch that one. I'm going to try to remember to link it up here. If you have an opportunity today, do something nice for somebody. We can make the world better one person, one place, one thing at a time. After you do something nice for someone, after you maybe make somebody's day, come back here tomorrow and we'll talk about something else interesting. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.